The third important landmark judgment delivered relating to intellectual property right, in particularly relating to either copyright acts or trademark laws and patent laws. We would like to discuss this judgment delivered in 2009 relating to BAYER Corporation vs. Union of India, where the very topic was relating to sorrow, pain, to and it was relating to next hour and by the NACTO Pharma Limited, and the very matter was pertaining to Indian Patent Act 1970. So the very fact was relating to grant of voluntary license, then the very demand of compulsory license, then the question of royalty. So the very legal issues raised here was section 94 clause F of the Indian Patent Act of 1970 and the sections further 48 and 156 of the Patent Act. So, hereby you would like to discuss this judgment and the very conclusion that we arrived. So, this landmark case of BAYER Corporation vs. Union of India in the year decided in 2009 set a precedent in Indian patent law by offering a more flexible interpretation of patent linkage, aligning it with the compulsory license framework and the application of the Bowler International Convention provision. The dispute involved where corporation, a United States of American based company holding a patent for the drug sorafenib tosylate used in kidney and liver cancer treatment, marketed as Nexavar in India. NACTO Pharma Limited, an Indian pharmaceutical company, sought a compulsory license after were rejected their request for a voluntary license. The court analyzed Section 84, Clause 1 of the Indian Patent Act 1970 and ruled in favor of NACTO Pharma Limited, meeting the requirements for granting a compulsory license. The judgment delivered in 2009 emphasized public health concerns and the importance of balancing patent rights with public access to medications, raising concerns about the impact of patent linkage on generic drug availability and market monopolies. So, the very arguments in this BAYER Corporation vs. Union of India and others was the first case which gave a liberal and more flexible interpretation of Indian patent linkage in line with its compulsory license regime and application of the international bowler provision. The company involved in this case, the petitioner BAYER Corporation, was based in the United States of America, as they researched and made a drug to help people with diseases related to kidney cancer and liver cancer. In India, in 2008, the petitioner brought the patent for a drug called sorafenib tosylate. This drug is sold under the brand name Nexavar. NACTO Pharma Limited was the company as respondent in this case? It was an Indian pharmaceutical company that was making drugs. So now we will discuss the very facts relating to this case that Bayer Corporation, as already we have discussed, based in the United States of America, did research and made a drug to help people with diseases related to kidney cancer and liver cancer. The petitioner got the patent for the drug in 2008 in India. The drug was called Surfavin Tosylate. The Ware Corporation turned down the very request and did not give NATO Pharma Limited a grant of voluntary license. After the 3-year period which ended up, NATO Pharma Limited put a request for a compulsory license. NATO had been given a forced license to make and sell the drug that were corporation invented and patented. Where corporation also asked the company to pay a royalty of 6% of the total amount of drugs sold in India. NATO Pharma Limited could not give the patent rights they were given to any of their heirs because they could not be given away or sold. So the very issues raised in this important landmark case relating to the Patent Rights and Patent Act, the first legal issue that raised whether the ones under Section 84 subsection 1 of the Indian Patent Act of 1970 were glad for granting a required license. The second important question, legal question and issue raised whether or not counterfeiters of a patent drug should be taken into account to see if an affordable demand test has been met. The third important legal issue or the question raised, does the Medicines Act of India consider a drug or formulation that breaks a patent to be a serious drug? So, in regards to that, we would like to discuss certain important provisions of the Indian Patent Act 1970 and in particularly Section 84, subsection 1 of the Indian Patent Act is providing giving out mandatory license. Compulsory licenses are given out so that patents do not get used as monopolies too often. Make it possible for someone who wants to do business with the patent invention to do so. Further, Section 48 of the Indian Patent Act 1970, which provides that exactly what kinds of actions violate patents. So, Section 48 of the Indian Patents Act 1970 gives the patentee the right to stop others from making, importing, using, selling, or offering for sale the patent invention. In that connection, we would like to discuss the very provisions of Section 156 of the Indian Patent Act 1970, which provides that patents can be used to bind the government. Relating to other parts of this act, a patent has the same effect on the government as it does on any other person. So now we would like to discuss the very judgment. So, in this important landmark case relating to patent law, where Corporation vs. Union of India decided in 2009, the court ruled that all three of the requirements as provided in clause A, B, and C of section 84, subsection 1 of the Indian Patent Act 1970 for giving an obligatory license had been met. Further, the court said that the question of whether or not the general public has been met should be answered by looking at the evidence that each party has brought forward. That kind of linkage probably hurts the BAYER provisions, which helps generic medicines get to markets after their patents expire quickly. So, that was a serious idea for public policy in India, which has a lot of public health problems. So, finally, we would like to conclude the very relevant judgment that was delivered in 2009 in this important landmark judgment relating to patent law. That is where Corporation versus Union of India. So, where the court held in favor of the respondents and said that the instrument petition could be put up. Patent linkage forces regulatory authorities to do something that is totally in two different areas. This means that legal rights are constantly changing from being personal to being public. If patent linkage has to be used, it should be checked to make sure it does not get in the way of mandatory licensing. It could also stop foreign pharmaceutical companies from having a monopoly on the Indian market. So, in our next upcoming lecture, we would like to discuss another important landmark judgment, and that is also relating to the patent law and in particularly the Indian Patent Act 1970 would be Novartis vs. Union of India, which was decided in the year 2013.